Today I'm speaking with Dahlia Lithwick, who is a senior editor at Slate and writes a commentary called Supreme Court Dispatches. You've been covering the Supreme Court your 10th term, so you've seen a lot of cases, a lot of justices come and go. You're a lawyer yourself, you have a good sense of history of the court. But let me ask you, I grew up in the 1960s and went to law school right after the 1960s, very into civil liberties and all that. I'm a big fan of the Warren Court, the Brown versus Board of Education, the Miranda case, and all these cases that just kind of like flowers in the wilderness, and the things were liberated. And my opinion of the Supreme Court always is they're there to do justice, to correct things. Now, back during the Rehnquist court, as I understand, they were hearing 170 cases, or so. Now, in 2007, it was less than 70, and 74 this last term. They're not hearing many cases. So I guess the question is, what happened? I don't see the old philosophy of let's do justice. What's happened?
Well, I think a large part is a reaction to the sense of your flowers blooming in the Warren era. I think that so much of what we're seeing now in the Supreme Court is the court itself struggling with this institutional question of how large a role the court should play in the life of this country. And I think that the Warren Court spawned perhaps great liberties and great new freedoms and great new checks on the idea that the court had its hands off on everything. But perhaps as a consequence, the court inserted itself into every fundamental question and area of American life. And what we see now is a blowback to Roe, a blowback from Brown.
Pendulum swing.
Yeah, and I think that if you look at, it's not an accident that the Roberts Court, so many of the more conservative jurists came of age in that era. They came of age in a time where they were going to law school and Vietnam scared them, the protests about Vietnam scared them, the sense that the court was just letting the horses run wild scared them. And I think doctrinally, they were really bothered by the lack of rigor. I think that they felt that no matter how good Brown v. Board was or how good Roe was, that these were just not defensible, logical positions. And so they really, I think, arguably overreacted to that thousand flowers bloom view of the 60s and 70s. And what you see now over and over again is the court grappling with this institutional question of how do we get ourselves out of this?
If you go back 1954, Brown versus Board of Education, it was really, if you look at that case, it helped spawn the Civil Rights Movement, Martin Luther King, the Civil Rights Act. So what the court actually did is they just planted a seed and said, enough's enough. We don't treat African Americans like that. To me, that was the philosophy. I don't see that philosophy in the court, but I guess the question is, should the court have that philosophy? Or, as Roberts says, the new Chief Justice, he's an umpire. And I've often said, I don't want an umpire on the court. I want someone who's going to make a decision that's going to make it better to live in America. You have great gay rights issues now. All kinds of issues are coming up that are really important. Do we really want them ducking those issues, or do we want them deciding those issues, right or wrong? Is it a moral question?
Well, I think that cuts to the heart of the fight between conservatives and liberals on the court right now, is that John Roberts would tell you it's simply not the place of the court to decide those issues, and that as an institution, the court is at its best when it defers to the elected branches. Now, that means that what you're seeing in the Roberts Court is not only an erosion of rights, of basic civil rights, you're also seeing, I think, an institutional position that says the court only serves to sort of ratify what majorities want. Now, that can't be right. I mean, the court was supposed to be a check on the majoritarian branches of government. And so there's a real question about access to justice. And one of the things that I think falls to the wayside when you talk about the Roberts Court is how much they've limited access to justice. We saw it this year with the DNA case. We saw it this year with the old age discrimination case. We saw it this year with the slow erosion of the Voting Rights Act, the slow erosion of disparate impact doctrine in Ricci. So what you're seeing is a contraction of the fundamental ability to walk into a court and make a claim.
And get justice.
Yeah.
One big criticism of the Supreme Court, and it's come from many different quarters, and I've written on it, is when the Supreme Court was instituted by the so-called Founding Fathers, the average age of a human being was less than 40 years. So when they said lifetime appointment, you're talking 5-6 years. In fact, Jefferson argued he was really against lifetime appointments. Thomas Jefferson, he said 6 years was what he came with term limits. Is it time for term limits in the sense, and maybe adding a few more justices to the Supreme Court so we can get more diversity? I mean, now we have Sotomayor, who's going to be on the court. You have 2 women, but there are, it doesn't reflect the demographics or the views of America. Don't we need more justices maybe to the Supreme Court? Term limits so we can get new blood, and you get judges on there now for 30 years, and sometimes they're not very good judges.
Well, I think that I agree with you to a point. I'm actually not for term limits, and I don't think I'm even for packing the court with more justices. But I do think that one of the things to keep in mind as a sort of counter argument to that is John Paul Stevens, who is a guy who grew up in a totally different era and yet gets the internet. David Souter, someone else who understands the internet in a way that you and I probably don't yet. John Paul Stevens was the one during the Reading, the strip search case, who seemed next to Ginsburg to be the only person on that court who understood what an affront it would be to strip search a 13-year-old girl without her parents' consent. So whenever people say, oh, the court is old and out of touch, I always have to sort of bring them back to the proposition that the oldest, whitest man on the Supreme Court often gets it in a way that people who are many years his junior don't.
But he came out of the 60s era. We may not get that again. That's what I'm saying. I think what we're really looking at here is what is the future of the court? I mean, you have an Hispanic woman coming on the court who's actually said that as a Hispanic, she probably understands things better than a white person. And to be honest with you, I agree with her on that point. Because you look at the Supreme Court, you have mainly Ivy League people sitting on the court. Why couldn't we have a more diverse court where you have someone from Utah that went to the University of Utah? They seem to be stacking, the court seems to be stacked with Harvard, Yale, those kind of folks. It's not really representative of America. It's East Coast establishment. Isn't that a criticism or a valid criticism of the court?
Well, I think it's a very valid criticism, and one of the best examples of that was President Obama saying he was going to reach out from beyond the Ivy League bubble, right, beyond the hermetically sealed courts of appeals, and find somebody who had real life experience. You'll remember Jennifer Granholm was on his short list, Elena Kagan was on his short list, and yet he picked a federal appeals court judge who'd been on the bench for 17 years. So it seems that our rhetoric doesn't always match up with the reality. I think part of that is a function of this confirmation process, which is so utterly toxic and utterly surface and
very political.
Very political, and it would be very hard, I think, at this point in time for a president to reach out and pick someone who, for instance, had had years as a defense lawyer or had worked, on the ground just trying cases. I think that just doesn't happen anymore, and so what you get is the complaint that the court is out of touch, but also the understanding that if you were to pick somebody who were in touch, they'd be utterly unconfirmable.
Thank you very much. Very interesting.
My pleasure.